of the view that we are already engaged in an irregularity.
Yes, Judge.
And in the purpose of applying to the High Court,
Supreme Court.
the purpose for doing that is to stop the continuation of the irregularity.
To set aside the irregularity and then to direct that, at least that is how what Minuma said should happen, is that the plea should be determined. I also intend to bring an application before you for a stay in the light of the Minuma information, which was not before court, and the irregularity was not before court when the court determined the point in limine. So it's a new fact that has arisen. According to paragraph 7 of Minuma, the onus is on the state to prove.
You want to bring another application for a stay of what?
Before you for a stay pending the determination of that jurisdiction
For
issue.
a stay of what?
Of the continuation of the plea taking proceedings. For a stay of the proceedings of the plea taking. Because that's what they are proceedings.
When do you want to do that?
I'd like to do both on that Friday.
So you're applying for what now?
I'm applying for a postponement.
To when?
Ideally, to now need to consider an opportunity. Well, the court must probably guide me in this, because if I file those papers, the state will probably have to respond. And if I just
No, which one is you are making an application?
yes, I'm applying for sine die.
Sine die.
And subject to the court's directions to case manage that application for the state.
Anything else?
No, Judge. Thank you.
Please.
Is an application for corporate postponement for the specific application. The state is taking the option of application because the postponement requested for any stage is not necessary because she calls me.
Slowly and now.
As it is a controversy. I submit that it's not necessary or expedient to have a postponement at this stage. First and foremost, this court has already ruled that until a determination is made by the court with regard to the jurisdiction of this court here in this matter, this court will continue to hear this matter pending that decision. And on the issue of jurisdiction, the court already made this decision yesterday that we will continue the case. So as he rightfully indicated, if he is not satisfied with the decision of the court yesterday, he said he's going to have it reviewed. That is well, it's within his rights. But today and this very morning, there's no need for this court really to postpone this matter pending some application that is going to be submitted by the applicant at the future date. We can continue the plea taking proceedings, and once he has filed his application, then at that stage, he can bring his application for a postponement. We will deal with it at that stage, but that should not delay the hearing of the plea proceedings today. I respectfully submit to the worship that we should continue with the hearing of the case today. His intention to file his applications next week or in the course of this week whenever it was not the latest proceedings.
What you are facing is an application for a postponement.
Yes, Your Worship.
So that application made orally must be decided.
Yes, Your Worship.
And your position is that it should be dismissed.
Yes, Your Worship.
Can you just go over the basis for that position again?
Yes, it is about Your Worship. I just want to highlight, first and foremost, it's already indicated in the content of the issue of jurisdiction. So it's not a new issue for this court. That is the first point. And secondly, you have to challenge that decision as indicated it's going to. It's more than entitled to do that, but there is nothing pending for this court at this very moment. There is no application to challenge any of the court decisions that have been found at this stage. So that, at this moment, when there is nothing to talk about, should not be used as a basis to postpone the matter just before the party intends to have something done in the future. Whether or not it's going to be done, that depends on them. We've been told they're going to appeal some of the other judgments which have been delivered by this court, but we've not received anything to date. So postponing this matter, which has been pending for years, is just going to cause an unnecessary delay in the proceedings, and that will not be the interest of justice.
How does the application for postponement on the grounds stated exists side by side with the last judgment I made?
With regard to the issue of jurisdiction,
No, with regard to the issue of continuation, the last written judgment.
yes,
In fact, that we will continue reading.
yes, Your Worship. And that judgment still states. So these are merely attempts by the applicant to delay this matter. The court has already ruled as to what will case this matter, and the court will continue with the proceedings. The issue of jurisdiction has already been decided by the court. The court has made its ruling, so that should not delay this matter anymore, Your Worship.
Anything else?
That will be all for this submission, saying no opposing application for the postponement.
Mr. Shanghala,
Thank you, Judge. First of all, I want to correct the state's position. I have not ever in this court indicated that I will appeal those judgments. What I've indicated is that I'm entitled to DS to consider the appeal, and that those DS have not yet been exhausted. That is one. Secondly, you will note, Judge, that the state refrains from making any remark as to the issue that I raised, which is the irregularity, that they ought to have established that the court has jurisdiction. The court did not give them that opportunity. That amounts to an irregularity. But over and above that, what I expected them to say is that it is not just that they need to establish, them the state, that there is jurisdiction. They are also required to do so and prove so beyond a reasonable doubt. Paragraph 7 of Mnuma says, where a special plea of jurisdiction is raised, the prosecution bears the onus to prove beyond reasonable doubt that a Namibian court has jurisdiction to try the accused. In brackets, R.V. Radebe and others, 1945, Appellate Division 590 at 603, close brackets. Which means that the irregularity committed is twofold.
what was the jurisdictional objection in Munuma?
That's besides the point, Judge.
I'm asking that question because you cited this. It is important.
Yes. In Munuma, you had people who were brought from another country to stand trial in Namibia. The issue, and I can go into it about whether or not, what's the guy's name?
No, what I want are just the facts, the relevant facts in Munuma.
Yes, that's why I stayed away from the facts. I went to the law that is stated in Munuma. That law comes from Hadebe.
No,
I can't even remember what's
Mr. Shanghala. Every case deals with particular facts.
Yes.
And cases are distinguished on the basis of facts.
Correct.
Of each case.
Correct.
So when I ask you about the facts in Munuma, it is an attempt to see whether Munuma can be distinguished from the present case on that issue.
Then I would also have to look at Hadebe, which Munuma relies on.
I'm just asking about Munuma. I'm asking about Munuma. What were the facts in Munuma?
In Munuma, you had persons in a treason trial who were brought into Namibia from Botswana to stand trial. The court had to determine whether the manner in which they were brought into Namibia was proper and legal to bestow the court of jurisdiction. It ended up releasing and discharging the person, I forgot his name, or accused 7, because the way he was brought in was not proper. That's a general outline of that case. But the point is this, I'm zeroing in on the law. That's why Hadebe is referred to. It's a legal principle that bears the line of legal reasoning. Facts aside, the court yesterday did not allow the state to prove that there is jurisdiction, and to do so at the threshold of beyond a reasonable doubt. So the state hasn't addressed that. That was what I was addressing. The second issue was that the state hasn't addressed that issue. They should have addressed it, because if they would have addressed it, being legal practitioners, they would have been in a position to help the court understand that that irregularity shouldn't be allowed to continue. And the only way to cure it is through a review. The Supreme Court has all those powers to review. For me to do so, I would like an opportunity to be able to go and prepare myself for that. I would like also to disabuse the prosecution of what is called a delay. You see, judges, they are not interested in the fact that I've been in detention for 5 years in their instance. I don't know whether I'm in detention, in prison, as a punishment or for punishment. In this anticipatory punishment, I don't understand why it's for.
You're saying you're in detention at the instance of who?
The state.
Oh,
They oppose
the
my
state.
bill.
Okay.
Yes.
Mm-hmm.
Yet they're only interested in speedy trial for the sake of speedy trial. The judge will recall that on 5 December 2023, I addressed this court and I said that this is a construct of principles. It's man-made, it's not God-made, it's man-made. The principle that you can sit there in a row and we have to bow with.
Are we still dealing with the application for postponement? Can you focus on that application?
Yes, I'm responding to the allegation that this is an attempt to delay. You surely would allow me to dispel that and disabuse any thinking that this is an attempt to delay. And I'm saying, I'm anchoring my application for a postponement on my belief of a principle. Hence I said that this is a construct of man, not God. That is very relevant and germane to the argument, if you ask me. And where my train of thinking leads me to is the conclusion that if we believe in principle, we must believe in principle all the time. That is why I say Article 12 says impartial, independent, competent court. That is why I apply for the determination of the jurisdiction. That principle that I put in that case is the very principle that leads me to raise the plea of lack of jurisdiction. Because I believe that the court can be competent and not just speedy trial for the sake of speedy trial. Because we might as well go in the field and get the baboons and then we tell them, judge this case. Because we want a speedy competent court. It has contours.
Have you finished your response?
So,
can you finish?
Point I want to
Sorry, you have a right to reply.
Yes, I was.
You have a right to reply. You have no right to raise new points unless you apply.
No, you are correct.
Yes.
But I believe that I was not raising a new point. I was replying to the issue, the notion that we are delaying the trial for the sake of delay. And I don't want to repeat myself. I think I've made that point very clear. It must be disabused. If we believe in a principle, we believe in a principle. Period. It cannot be Shanghala law, Fishrot law, or whatever. It must apply all the time.
So
The last issue that he raised, which I would like to respond to, Judge, is that the clarity he probably didn't have is in that I say that I intend to bring an application simultaneous with the review to say that whilst this review is being considered on that irregularity, we should not continue here. Because if we continue in the fashion that the judge has determined in the determination you made on the 6th of December, that judgment on the plea taking, and apply it in the manner that you applied it yesterday, then we continue to commit the irregularity. So those applications will be brought simultaneously. That is the clarification on, perhaps that's where you didn't quite understand. And Judge, clearly you were right about the fact that there is an application. This is an application. If you would like, I can give authority that applications in criminal matters need not be brought in writing.
we are done with that. That's why we are entertaining your application.
Thank you very much. I have answered.
My last question, who else who identifies with your application?
Accused 6 and accused 2.
Can I get confirmation?
And the entities.
Can I get confirmation from Mr.
Excuse Judge. I made formal calls with Mr. Shanghala.
Yes, and for your entities as well.
Even my entities as well.
Mm-hmm.
I'm in common cause.
I'd want to give an opportunity to the other accused persons, since you are representing yourselves. Any one of you wishing to say something about the application? There's an application that this matter be postponed indefinitely, so that certain applications, review applications, can be brought.
Qualification to that, if I may. It is that the application for stay is before you. You'd have to case manage that issue. I was unable to give you a case, hence I was forced to send it.
Have you thought through that one?
What?
What I'm saying, have you thought through whether the application for stay should come to me or it should go to the Supreme Court, where you apply for a review together with the stay application? Have you thought through that?
Admittedly, Judge, I have not thought through. I'm still.
All right, but I understand you want to bring a stay application before me. I'm talking about the postponement, which you have said is indefinite.
Well,
yeah, I can't carry on. I'm giving the other people an opportunity to talk. You have said the application for postponement, the matter must be postponed sine die, which means indefinitely, isn't it?
yeah, well, I clarified the sine die as it is important.
Yes. Can I start with the order? Sorry, can I start with the order so that I don't get confused? Mr. Gustavo. Sorry, you said you have nothing to say? To add or to say? Okay. No. You see, when there's an application of postponement, I'm not saying say anything. When there's an application before the court, the interested parties are given an opportunity to say what they want.
Right.
Yes, so if you have nothing to say, that's fine.
Yeah, my view then is that if there is an irregularity, then I guess the court, I would support that the court need to provide that or please consider.
Yeah, but you got you guys say if we don't operate
That's for the
on
court to
if.
decide.
No, I've decided that we proceed with the plea taking. He thinks there's an irregularity which he wants to take, for which he seeks a postponement until some other court tells us that there's an irregularity. So either you identify with that application or you don't.
I do.
Okay. So that is a big move from saying I have nothing. Yes. Is it Mr. Bernardt Esau? You want to say anything?
A very good morning. I would identify myself what was moved by Pius Shanghala.
So you identify yourself with the application for a postponement. You can move a bit. I'm saying so you identify yourself with the application for postponement sine die. Means without a fixed date, without a date fixed for the matter to resume. That's what sine die means.
Yes, I understand. I cannot be in suspense because in sine die, it's a little bit very difficult for me to accept that indefinitely. There must be a time frame in place for this matter, for this irregularity to be attended, not in sine die.
So to what date would you want it postponed to? To what date would you want it postponed to?
Reasonable.
Well, I'm asking about your reasonableness. I'm not going to dictate what is reasonable to you. You tell me, you are identifying with the application for a postponement. The only difference you say is based on the time when the court must resume. He has proposed sine die indefinitely, and you are saying no, not indefinitely. So what are you saying?
My Lord, I am not the court. I am not court as well. And I cannot determine how long I am on this earth. Neither can I determine even how long the Lord is here on earth. So that is why I'm saying I'm indifferent in terms of time.
So if you are indifferent, you mean sine die is fine with you, indifferent?
No.
Because when you say you are indifferent, you mean I don't really mind whatever happens.
I am mindful of whatever happens.
So let's cut a long story short, Mr. Esau. He says, I want a postponement sine die. What is your position?
My position is it must be reasonable.
What is reasonable?
Reasonable.
Hmm?
My Lord, taking reasonableness is determined by various factors. There are various factors that determine reasonableness.
I agree, but when you have considered all those factors, what is the reasonable period of postponement?
Factor of my age, number one.
No, I'm just saying consider all those factors, all the factors. when you have considered all the factors, when do you think we should have it postponed to? That's all. You consider every factor you have in your head and say the reasonable period for such a postponement must be up to such and such a time.
It's a tall order you allow to ask in terms of time.
All right, I'll take you identify with the application except in respect. Postponement must be reasonable. And you are speaking also for your entities, isn't it?
Sorry?
You are speaking for your entities as well, whatever entity you represent.
There I have a problem, my Lord, because I have not been given mandate even through resolution or decision to speak
So-
on behalf of that when I will come to that. But that when
Now, Mr. Esau, who is the, according to your knowledge, who is appearing or representing your entity here? Who is there anybody representing your entity's number what? Number 20?
24.
Yes, who is representing it?
My Lord, an entity consists out of members, it's a CC. And that very CC is an entity on its own, and I am in my
Yes, I understand.
Two, when in fact,
Yeah, let's answer
And
questions.
I'm getting to the question.
Let's answer questions rather than explain a lot. Do you know whether that entity, which is accused number, you said 24, is it represented by anybody in these proceedings?
the entity is charged,
Yes, it's charged.
I am charged,
Yes, you are charged.
and I'm a member of the entity.
Yes.
And I need, the entity is supposed to take a resolution, a decision.
Is anyone representing accused number 24 here? If there's no one representing it, you tell us that there's nobody representing accused number 24. Then we take...
By the state, my Lord. As a member of the entity called accused number 24.
My understanding may be slightly different from you, from your understanding. My understanding is where a legal entity is charged, it is charged in its own right. But then someone from that legal entity, could be the GM, could be the director, is also charged or is supposed to represent that entity. And all I'm saying is, number 24, to your knowledge, is it represented by you or it's not?
My Lord, that is for the arguments in the case. Because there is no managing member. Both of the members of those, because it's more than one, there is no managing member. There is no, in fact, documentation.
So the answer, simply put, you are not representing accused number 24.
I am not given the mandate.
You are not.
I am not given the mandate.
So without a mandate, you are not representing.
Nobody is representing me. There must be a mandate, a written one for that.
Yes, now we have the accused number 5, Tamson. And then we have Mr. Mike Nghipunya.
Yes, my lord, I came here to plead, and I think the court will have to consider the fact that I have been coming to court since the last year, October, preparing to plead, and I have not had that opportunity. And I was hoping that yesterday, at least, with the ruling that we continue to plead, I will be able to plead this before the pre-court.
So you oppose the application for postponement?
Yes, I oppose the application, and I want to
Mr. Shuudifonya.
Yes, Your Lordship. I have no objection in the postponement.
And you are happy with the postponement sine die? Huh?
Reasonable postponement.
Sorry?
Reasonable postponement.
What is reasonable postponement?
You will, I will ask you a question.
Yes.
Okay. So I think the applicant should provide that time frame.
No, the applicant has said indefinitely, sine die.
Okay, I will put it in the report.
Yes. Then accused number, Mr. Mwapopi.
Judge, my intention is to come here to plead, and I want to continue to plead. However, I'm not against anybody who is trying to exercise his own right to ask a court to consider whatever is being fought. I read the head of the court, and the court should consider my right to say, I want a speech trial. I want to finish this and go.
So you are not opposing, neither are you.
I'm not opposing, neither I'm saying whatever, but the court should decide. Considering that I want to speak time.
Yes. Sorry, with so many accused persons, from Mr. Nghipunya, Mr. Shuudifonya, Mr. Mwapopi, you are all representing whatever entities you are charged.
Yes.
Yes. Okay. Then Mr. Van Wyk.
I'm 100% in support of the postponement.
Can you speak loudly?
I'm saying I'm 100% in support of the postponement from the request that came from Mr. Shanghala. I don't agree with the 7-year one.
With the?
7-year.
Mm-hmm.
My understanding of 7-year is there's no date. Yes. And I want to give reasons in the law. My Lord,
First, tell us when do you want it postponed to?
And, my Lord, it must be postponed to the date. The notice was filed on the 9th of December, last week Friday, where my legal representative indicated that it's only available 19th May 2025.
So you want it postponed
On the date when my legal representative
to 19 May?
Yes, 2025.
Yes. And And you are speaking for, are you representing any entity? Yes. Anything else? No, that's sufficient for my purpose. Is there anything arising for the state or for Mr. Shanghala? Mr. Shanghala?
I move to reconsider the sine die aspect of my application to accord with the proposal made by Gustavo, hoping that that will allow the Supreme Court to deal with that matter expeditiously so that we may proceed. And just to put it on record, I too would like to go home. I believe in principles.
So you are now modifying that to postponement to 19 May.
That is correct, Judge. Well, the first term of the Supreme Court, I forget that the Supreme Court has a term different from our dates. That is,
You can't go on just changing date.
I rest on I rest on.
Yes, I will give very brief reasons for my ruling now. We commenced the plea taking in this matter in December of last year. That process was told, as I've said in a number of my judgments, by a number of applications which have been disposed of. The last of my written judgments was one in which I directed that the plea taking will continue. That judgment stands. When we resumed the plea taking, the issue arose as to whether a plea to the lack of jurisdiction of the court was to be decided so that the matter of jurisdiction is laid to rest. The issue of the presiding judge's appointment is pending before the High Court. In that case, commenced by the applicants, they have sued the state president and other functionaries and cited the judge president of the High Court and myself as parties. That matter is still pending, and it was not commenced on agency. That means it will take the normal course of litigation in the High Court, unless the applicants approach the court for the matter to be dealt with on an urgent basis. The simple point that informs the plea of lack of jurisdiction is that challenging the appointment of the judge, which the applicants contend is invalid or unconstitutional. I have had occasion to pronounce myself on that matter. I have said that a decision was made by the relevant authorities to appoint me to deal with this criminal trial. That decision subsists. And as I said, and I will say it again, that decision subsists until it is set aside by a competent court of law. In the meantime, as I have said, I will continue to discharge my function to the best of my ability and will only stop when a decision has been made by the courts as to whether the appointment is valid or not, constitutional or unconstitutional, and there we will stop. I am very much alive to the fact that the accused persons before me have been in custody for just over 5 years. And they must be tried and a decision made as to whether they are guilty or not guilty of the offenses charged. A trial must take place within a reasonable time, failure of which the accused persons are entitled at law to apply for their discharge. Now, the application to postpone is based on a matter I dealt with yesterday, it being that the plea to jurisdiction is squarely based on the validity of the appointment of the judge, which, as I have said, is a matter pending in court. For that reason, I called upon the accused persons to plead to the merits of the charges read out to them. They allege that that procedure is irregular. It may not. The general law, as stated in Munuma, where persons were unlawfully brought into the jurisdiction to be tried, and those persons contended that the court had no jurisdiction based on the illegal nature of their repatriation to this jurisdiction, is different to the present case. The facts are entirely different. The court cannot be engaged in secular proceedings. The main point merely being to ensure that a trial does not proceed. In any event, any application for postponement is not for the asking. Sufficient cause must be established, and I don't find that the applicants have established good cause for a postponement. The state is opposed to that application, and insofar as the state is concerned, they say they submitted that it is not necessary or expedient, and that the position with regard to continuation of plea taking has been made abundantly clear. Further, that the court has dealt with the issue of jurisdiction, which, as I have said, is pending in the High Court. I do not find substance in an application for postponement. Sine die has originally applied for, or to 19 May 2025, the same date to which the parties had proposed the matter should resume. I therefore dismiss that application for a postponement and call upon the state to proceed and put the charges to the accused persons. That's my brief reasons for dismissing the application for a postponement. Yes?
I respect the ruling of the court, the decision, but you stopped me, my lord. I wanted to add something. I just wanted to have it on record as well. My reason was why I supported the postponement of Mr. Shanghala. I'm legally represented by Mr. Samherji, legal 800 lawyer. If you recall, my lord, on August, 16 August, you made a ruling on 2 applications by Mr. Shanghala, and you asked the legal representation, availability when we can proceed with the taking exercise. And on that date already, 16 August, my legal representative, Mr. Nghipunya, informed the court that he will only be available next year, mentioned April. Yes. And he informed to my law. And then last week Friday, he also served a notice at the registrar's office informing the judge that he will only be available from 19 May 2025. So I want to place this on record because this is a democratic country. We are bound by the Namibian Constitution. Fundamental human rights must be respected. And I feel, and I also respect the rights of my co-accused that they are entitled to a speedy trial. But I feel I must place this on record that my availability of my legal representative is only next year May. So I to that. We have the pending application. That application is done now. The ruling will come out on the 29th of January 2025. So I just think, my Lord, continuation of plea taking is infringing my human rights, my human dignity of a fair trial. I just want to take it on record, my Lord. We may proceed. Thank you.
Yes, Mr. We're talking about amendments.
Yes, there was an application to make some minor amendments. For the first, it's on page 62 of the indictment. Where it reads the total sum of 46 million Namibian dollars, 789,464.40 cents paid
What are you trying to achieve there, Council?
Excuse me, Your Worship.
What are you trying to, that you are talking about the charge which we dealt with yesterday?
Yes, Your Worship. The only amendment that we want to make, the way it reads accused 9, then 9 should be accused 13, Your Worship. So, 9, then 9 should be 13. Yes, at D, page 62, the first paragraph B, the first line. Instead of the 9, it should be 13. Accused 9, yes, replaced with 13.
I'm looking for that. Where is it? Is it D or E or what?
D, Your Lordship, the very first line at the top, at page 62. Where it reads, paid into accused 9's bank account.
You are saying it must be what?
Accused 13.
So what do you suggest we do now?
Your Lordship, there's still a request for an amendment of that particular charge for accused 9 to be reflected as accused 13.
And then what do we do next?
I'll deal with the issue of prejudice. I wanted to deal with it at the very end once I've dealt with the other minor amendments that I intend to make before the court.
So why don't you deal with that amendment when you want to deal with the whole matter? Because I don't quite follow what you intend to happen.
Yes. For this particular count on that line, the state request to replace accused 9 with 13.
Yeah, and then what happens after that?
The accused persons can indicate what their position is. Do their pleas still stand despite any change?
The whole point I'm asking these things, I think the state must be very thorough and ensure that you place all your amendments together. When people plead, they plead to the charge as framed. There's no point a person pleads to this charge, tomorrow you say, no, that charge is not correct, we must be, so that's why I was asking you about the procedure. Do you put the charge to them again or what?
No, there's no need to put the charge again, Your Lordship. The amendment can be done now because what is required for amendments to be done. An amendment in terms of section, I think it's a 6 of the criminal procedure, can be done by the court at any stage before judgment is given. So even if evidence has been laid, there is an error.
That is why I'm wondering why, in respect of a charge we have dealt with already, why you are raising it at this point, rather than waiting until the appropriate time when you can still make an amendment.
Your Lordship, it's still appropriate to make an amendment at this stage because what is required is before judgment. So there's no indication as to what step before judgment. It can be during plea proceedings, it can be after evidence is laid. As long as the error has been noticed, an application can be made to the court for the correction of the amendment at any stage before judgment, Your Lordship.
I was just talking about the timing of the timing thereof, because that I know, even when when the trial is started, amendments can still be made. But I'm just saying this time is a bit, right. But anyway, can you go through all your amendments? Are you going through all your amendments in this indictment?
I want to go through all of them at this stage with one application and deal with them with one application. The second amendment, Your Lordship, will be at page 89.
So from 62 we go to?
89, Your Lordship.
Yes.
89.
Yes?
Your Lordship, at the second line, it starts with the appointment of the first accused in such a possession or fraudulently done. The state request for the first to be removed, to be replaced with 7. Page 89, the second line, first paragraph, second line, where first accused appears. It should be 7. 7. Mr. Nghipunya. The next one will be at page 98.
Sorry, page 89, the appointment of, it now must read the appointment of the second accused.
7, Your Lordship.
Huh?
7. 7.
Not second,
Not second, 7.
number 7.
Yes, Your Lordship.
Okay.
The next one will be at page 98 of the indictment. Page 98, the third line.
Yes.
Yes, Mr. Esau has picked it up. Accused 1 should be accused 7. Same with the last request.
First line,
Yes,
conspiring with,
accused 7. As for the next one, it will be at page 104. At first paragraph, the 4th line, where it reads, conspiring with accused 1 and 2 to commit an offense of contravening section 43, then it goes onwards. The 1 and 2 should be deleted.
the what?
1 and 2, accused 1 and 2,
Mm.
and replaced with accused 7. Furthermore, Your Lordship, still in the same paragraph, where at the very bottom where it reads, in respect of accused 2, 7, 8, 23, 25, 27 to 28, the state requests for the deletion of accused 2, 7, that will be all for that count. Your Lordship, with regard to these minor errors in the indictment, this came about as a result of having to change the indictment when other accused persons had been removed from the indictment. I respectfully submit, Your Lordship, in this particular case, the accused persons had not reached that stage where they had not provided clear explanations to the court. And at this particular stage, the court has determined whether or not the accused will be prejudiced in their defense in order for the court to determine whether to allow these amendments. I respectfully submit that there's going to be no prejudice at all to the accused person in their defense. In actual fact, we don't really know what their defense is insofar as these proceedings are concerned. So these minor amendments, Your Lordship, I respectfully request for the Honorable Court to allow the court to make these amendments on some of the charges they're not even pleaded. So there's going to be no prejudice at all to the accused persons.
So you just,
On the charges where they pleaded, their pleas stand. If they want to indicate there's some form of prejudice they will suffer in respect of their pleas, then they are free to do that with the court. Your Lordship, they have an opportunity to do that with their court.
yeah, so our amendments are at page 62, 89. I just want to,
98 and 104, Your Lordship.
98 and 104. Is it not neater, well, everyone has taken note, to deal with the amendment when we come to that, unless they have a blanket answer to all of them?
It depends on the views of the court. We are amenable if that is what the court requires. We can do that in the sense of the Lordship. I just intended to dispose of them with one application, but we can deal with them individually as we get to the Lordship.
Yeah, because I think people need to properly read them, isn't it? And then see the effect of the amendment, or especially when the charge is read to the individual concerned, he can then quickly reflect there and then, and with what you have done now, they've taken note of the amendments you intend to bring. It is only in respect of the alternative count that I may want them to respond. At this point in time, they can respond to the others later. But let's so that we finish with what we did yesterday.
Judge, my apologies. Is it possible to request that at some point we can receive this amended version of the indictment electronically? It is easier for us to then cross-reference and to check the document. Plus, I also recall that previously you had some engagement with the prosecution when you were in that court in relation to one of the charges. I think it related to accused 10. I can't remember if I had properly recorded where that had happened. I think it was come through. But if they can give us eventually this is the document with the amendment to intend, or eventually these are the amendments that the court has granted, it would help.
Well, actually, it would be neater.
Yes.
To just have a complete charge sheet.
Yes.
All the amendments.
Yes, Judge.
Because now you have had certain charges placed before you alleging certain things, isn't it? And it's neater always to have a final copy. If it was a one-page indictment,
Yeah.
so I think the state, would you mind, unless you can respond to the charges now, so that they just bring up one complete set with all the amendments there.
It is also possible for them to just give us, in the market with the header and the footer, that pending final determination by the court, and they give us a date on it. And then when that whole exercise is complete, then give us one. And I ask electronically, Judge, for a purpose. As you know, this court is so small. If I were to bring the documentation and have what I have, it's chicken soup around here. It's a pigsty. I can't just be able to go through the various versions because this indictment has changed. And then also I need to cross-reference with the manner in which they couch their understanding of their own indictment as the bail hearings are appearing. You know, the story has been changed. So that is why electronically it will be easier, and then I can pick my comments following that one.
Any problem?
There's no issue for the worship. There are just minor corrections that can there's no issue.
And then it's an electronic.
Yes.
Now, where you electronic?
Yes, sir. Sorry, I really cannot hear.
No, wait. Count 5, alternative. Count 5, it affected during
That's on page.
page 62.
I recall there was an amendment.
Yes, it is the amendment of page 62, right at the top.
Yes, paragraph.
In place of 9, they said up to 30. The first line of D.
Sorry, I just want to identify. Q's 13. Or G8. Okay. Yes, I have noted that one, Judge.
You have any problem with that amendment?
We'll deal with it, Judge. I have objections to the various parts of this indictment and the stories it tells. So,
Specifically, this one is going to be done with.
Judge, I'm saying I have fundamental issues with the story and the narrative taken in this indictment, but I have noted the amendment. And when it comes to a point, we will deal with it. But I note, there's nothing I can do. It's there, the administrators, they are charging me, what can I do? But when I yesterday indicated that I did not waive my right to challenge the indictment, I meant that I would come with my issues in the fullness of time.
What we are saying about amendment to charge, they are the 26. They have said it should be like that. If you are not proposing that amendment, then I think it is.
And I'm objecting to the entire charge. It's stories made by people who don't know what they're talking about.
Yeah, but
So if it's a comma here or whatever, it's their story, and I'll deal with it. That's what I'm saying. I have
I'll
noted
take it that you deal with it later.
I don't agree with it. Sorry, Judge, I don't agree with it. That's the point I'm making. The fact that I am not specifically taking the view that you want me to take does not mean I'm in concurrence with it. If that is clear, that's what you mean, then I have no problem. I think I've made myself clear. I have issues with the charge sheet and the narrative that is contained in this charge sheet, hogwash nonsense. So what I'm saying is, I will deal with it, and I haven't waived my right. But what they want to amend, let them amend what they want to amend. I don't agree with it.
This is
My Lord, it's an alternative to 5. And I have pleaded on the merits as it was put to me by the state. Now the state is coming to change. I am not ready to plead any amendments. I cannot, because I pleaded yesterday, the 11th of December, 2024, the year of the Lord. And I pleaded. For me now to plead on an amendment on errors or omissions made by the state, I cannot. Thank you very much.
But you come to that matter later.
Sorry.
Your amendments. The charge. And then
Says it is what. May I proceed the counts? as it is the court, that the accused are guilty of the crime of contravening section 34B, sections 132, 46, and 49 of the Anti-Corruption Act 2003, Act of 2003, and further has read the sections 94, 155, 156, and 352, subsection 5 of the Criminal Procedure Act, Act number 51 of 1977, corruptly giving gratification as a reward. This is in respect of accused number 1, 2, 5, 6, and 11, 22. In that, from a date more precisely unknown to the prosecution, but before and including 8 December 2011, and continuing thereafter to 27 November 2019, and subsequently thereafter, 8 of near Windhoek, in the district of Windhoek, and or elsewhere in Namibia, and or elsewhere outside Namibia. The accused persons 1, 2, 5, 6, 11 to 22, and the Samherji group of companies and its representatives acting in common favor, be directly or indirectly, corruptly, and intentionally give or agree to give third and fourth accused gratifications to wit, paragraph 8, unquantified sums of money and other benefits for the benefit of accused persons or for the benefit of another person and or entity as a reward for having done or having completed to do anything to wit, securing continuous allocation of fishing quotas for the Samherji group of companies through the guise of the MOU, and thus the accused contravenes or the sections 1, 32, 46, and 49 in the Anti-Corruption Act 8 of 2023.
I will enter for you if not guilty. Yes. That will repeat. Yes, you understand the charge?
No, I don't.
Yes, what
That is the principle of the question. The allegations in this particular account, the worship is that as it pleases the court. The allegation is that they intentionally agreed to give money. So when you say it's unquantified, it's because when one looks at the indictment, when those agreements were made from the documents which are available, it is not known in how much the fishing quotas which were going to be allocated would have been at the end of the day. Because there's a continuous process of issuing quotas to these entities. So it will not be said in that particular sum, in that particular state that this is the specific amount of quotas you are going on. You will receive these quotas until such and such a date. This is the sum of money which will be received, and you receive this amount of money such and such a date. So it's not known what the exact sum of money is, which was agreed on. That's why it is said unquantified. Because it was a continuous.
The essence of the charge is what?
For actually giving gratification.
In an amount unknown.
Yes, and where it is unknown by the prosecution, you can allege that the amount is unknown. It's similar to a case where, let's say the prosecution is alleging that salt was stolen by the accused person. We don't know the quantity of that salt. We can allege that it is unknown. It's unquantified, but it's the amount of that salt or the value of that particular salt. And that is why it is said here unquantified sums.
Mr. Colleagues, you now understand what you're saying?
You are actually more confused because money is a unit of account.
That's what they're saying.
Cannot be afforded.
Can I try to assist? When you read it, they say, acting in common purpose, did directly or indirectly, corruptly and intentionally give or agreed to give the third and fourth accused gratifications in an unquantifiable amount. So the amount is not known to the state, but they are alleging that you agreed to give gratification of an amount unknown. So there's an essential nature or essential or the essence of the charge as I read it is that you agreed to give gratification to the third and fourth accused in an amount which is not known to the state.
So, Judge, English is not once you talk about quantified sums of money, an amount of money is not
Sorry?
the amount in quantified sums. Once you are summing money, sums, what is being quantified? What is the money? Money is a unit of account, economics.
The point, unless I am not clear. Let me give you an example. I can think of the if two people agree that they want to give someone money in return for a favor, that agreement is there, isn't it? Or the state says there is that agreement. And then the state says, well, that agreement exists. We don't know what amount they were going to pay. Now, don't confuse a charge, because you see, don't confuse a charge, whether poorly drafted, whether incapable of proof, and whether you understand what they are saying. You see, there are two different things. With this charge, you may very well come up and say, sure that well they don't know what they are talking about, isn't it? And then on that charge you are acquitted. That understanding of what they are saying is what we are concerned with now. Not that what they are saying is established as fact. The state is entitled, as it has done, to make its allegations. When we get into the trial, they will prove. And if they can't prove what amount whether there was an agreement or in what amount, that's a different matter. And if they can prove those things beyond a reasonable doubt, then you go scot-free.
I thought, I don't know if it's such a fact in the CPA. It talks about that, and I thought the charge.
Sorry?
The charge must be clear, and I must be. The charge must be very clear through section 85 of the CPA. Once we start getting unqualified sums of money, in my mind, it's not. So, but anyway, they do not deliver the ball. It's okay. My plea would be, just by my notice of yesterday, the state, which I expect the state to bear the onus in terms of jurisdiction, policies, but they bear the prove that there's no jurisdiction.
And I take it that from what we discussed yesterday, you are not willing to plead the merits of this charge because you are pleading jurisdiction.
Judge, if I think maybe you can help me. I'm not going to say. I think in the last the separation, Judge said, and I represented that the court assistant. Judge, if I read the CPA, the jurisdiction in these many cases are relative jurisdiction. Does not say this is specific jurisdiction for geographic area, this is jurisdiction for green country, and that jurisdiction in case law is defined in many ways. I've got many cases here in the defendant. We've had numerous people being abducted. One was led, 3 others fled in the recharge. So there's jurisdiction. And then 106.4 says if jurisdiction is plead, and there is no jurisdiction for the court, the court cannot continue with any other thing. That's my understanding. Can the judge really be something?
Well, I've said that before, and I've made my ruling. I'm not going to start a follow-up again. I have said, and perhaps this will help. The issue of jurisdiction here is based on the appointment of the judge. A matter before a different court to be decided there. And the appointment of the judge, I have said, is valid until set aside. In other words, I'm saying that plea of jurisdiction is not a competent plea on the facts of this case. If you argue that it is, if you want to do it that way, I have made my decision. And I can't go beyond that, Mr. Hatuikulipi.
I'm sorry, Judge. If I may, Judge, yesterday said the notice is to the state when we came back from Windhoek. I've brought the state here to senior prosecutors. Why can't they not speak for themselves?
On what?
On the jurisdiction issue.
They say that the jurisdiction issue has been dealt with. And that is what they were saying. So, but the whole point is this. Let me tell you, I hope we'll be friends at the end of the day. The point is this. In order for proceedings to carry on, that is why the court is empowered to make interlocutor rulings. You apply for postponement, the court decides that there is no postponement like I have done today. You apply for this, the court says no or yes, and that's how it goes on and on. We can't keep saying, I've made my point, I want to make the point again and again and again. It doesn't help. So I have understood, when I seek clarification, I only seek clarification to know that when you stand by your plea to jurisdiction, you don't want to commit yourself in respect of the substance of has read to you.
There is no such provision in the CPA that the judge was doing.
Right.
If
If
the
there is
judge
none.
please help me with that provision.
So you are persisting with your plea to jurisdiction, isn't it?
Yes.
As I said yesterday, I will enter a plea of not guilty. Yes, now we start. Is the Tamson Hatuikulipi? You understand the charge?
Yes, I do, my lord.
Okay, thank you.
Not guilty. Beyond my entity. Of 13.
Yes. Mwatelulo.
I'm pleading in terms of section 106, 1F of the CPA. That is to say that this court does not have jurisdiction.
That is what you are of. Do you have any entities?
15 and 16 accused.
Please give me take a note of whether all the entities are.
Pardon?
No, I'm just saying the registry that we take notes whether all the entities are covered. So I ended up not guilty. I ended up not guilty.
That is the court's view.
Because if I do not recall, Mr. Gustavo Pedro, but for his NDA, so I don't recall him being for the and the present controversy presented to also confirm that they did for the 7 years ago.
I don't need a break, but I think my needs 5 minutes break. The agent is so weak. He had jealousy.
I do not know from the administration, they don't let me break at this stage.
I would appreciate a small help, Judge,
Yes.
but I couldn't really make out the rest of what you were saying. The acoustics are terrible, sorry.
Can you move forward, please?
The issue is I need to be close to the power cable so that I can power my computer, so that I have access to my documents. And this is the issue.
Just anyway, at the point I was asking whether anybody needs a health break for a short while.
Yes, I do.
And you say, so we'll adjourn for about 10 minutes. So that works.
Calling case number 6-21. Ricardo Gustavo and 27.
Since I did not make any note of Mr. Shanghala's plea on behalf of my accused 21 of follow last day.
We will need the summary. We should not on the side, but at least from the very good. Taken a plea.
I did not take the note of it.
Count 7.
Of accused 21 on count 7 years ago.
That one is represented in Shanghala.
Yes, it was.
And then you prepare a short showing this accused number 21.
What about it?
Is charged with this count, just dealing with count number 7.
Oh, if we to get to that plea of that's count 7.
Yes. So, and then it's it to be there.
As it is the court. Count 8. The accused are guilty of the crime of fraud as regulated for business of sections 94, 155, 156, and 3325 of the Criminal Procedure Act 51 of 1977 as amended in respect of accused 1 to 6 and 11 to 22. Whereas at all given times the accused of operating as a syndicate with the objective of accessing fish quotas while they were not right holders in terms of the provisions of the Marine Resources Act. Whereas at all material and relevant times the fourth accused was the Minister of Fisheries and Marine Resources. He was by virtue of his appointment, duties and remuneration therefrom a holder of public office. And whereas at all material and relevant times the third accused held the following positions. He was Minister of Justice from February 2018 until November 2019. Before that, he was Attorney General for Namibia from March 2015 until February 2018. From November 2010 until March 2015, he was the chairperson of the Law Reform and Development Commission of Namibia. He was, by virtue of his appointment, duties and remuneration therefrom the whole of public office. And whereas the Maria Seafood Namibia Pty Ltd, SJR Holdings Pty Ltd, Saga Seafood Pty Ltd, SJR Investments Namibia Pty Ltd, Icelandic Investments Namibia Pty Ltd, with Namibia registered on the Icelandic group of companies. And whereas Neil L.G. Arason was at all material and relevant times the director of SJR Holdings Pty Ltd and Maria Seafood Namibia Pty Ltd. And whereas Inba Julius Sen was at all material and relevant times the director of Saga Seafood Pty Ltd, SJR Investments Namibia Pty Ltd, and Icelandic Investments Namibia Pty Ltd. Whereas the accused 1, 2, 5, and 6 were related to the third and fourth accused in their capacity as described in general preamble above. Whereas the Maria Seafood Namibia Pty Ltd, SJR Holdings Pty Ltd, Saga Seafood Pty Ltd, SJR Investments Namibia Pty Ltd, Icelandic Investments Namibia, Ltd were incorporated or registered and operating in terms of the laws of Namibia and were related to accused 1 to 6 and 11 described in General Code. And whereas the fourth accused by virtue of his office and authority to exercise powers conferred by sections 35 and 39 of the Marine Resources Act. And whereas the Icelandic-based Samherji group of companies wanted to get into the Namibian fishing industry by any means necessary and approached the fifth accused and ultimately the rest of the accused as after the General Code. And whereas the accused played a role described in the General Code acting in concert and or with a common purpose and in furtherance of the common purpose. In that, from a date more precisely unknown to the prosecution, but before and including the ending of June 2014 and continuing thereafter 27 November 2019 and beyond, and at or near Windhoek in the district of Windhoek and or anywhere in Namibia, the accused persons acting in common purpose and or in conspiracy did wrongfully and lawfully falsely and intended to fraud, gave up and retained and or misrepresented the principles and or appointing authority and or to the cabinet and or to the Minister of Fisheries and Marine Resources and or government of the Republic of Namibia that A, the fourth accused then negotiated and subsequently signed the MOU on the 18th of June 2014. B, the fourth accused was executing his mandate in the best interest of good government. C, the fourth accused prioritized the economic development of the Republic of Namibia and sustainable maintenance and development of its marine resources. D, the MOU constituted a fisheries agreement in terms of the enabling legislation. E, the MOU was meant to promote sales resources between the two countries. F, the MOU promote mutual beneficial economic relations between persons of their countries who or which are involved in fishing, fish processing, marketing of fish, and fish products and aquaculture activities, and to develop institutional and business cooperation with the implementation of the management system of quality assurance in the fishing and fish processing. G, the fish quotas that have been allocated to the 11th accused have been allocated to an unwalled registered company which gave a joint venture with in terms of included fisheries agreement. H, there was a reciprocal arrangement with the Republic of Angola where Namibians were benefiting in the same manner. The accused did then and there by means of the said false pretense use their principles and or appointing authority and or the document and or the Minister of Fisheries and Marine Resources and or the government of the Republic of Namibia to I accept and believe that representations as the truth. J, allow the court accused to include and sign the MOU. K, publish proclamation number 22 of 2015 in Government Gazette number 5785 on the 17th of July 2015, wherein the memorandum of understanding was published in terms of section 36 of the Marine Resources Act 27 of 2000 as an agreement of cooperation in the areas of fisheries and aquaculture entered into by the government of Namibia and government of the Republic of Angola. I allow accused 4 to continue to allocate fish quotas to the 11th accused to a total of 50,000 metric tons over the period, to the actual or potential loss of prejudice to their principal and or appointing authority and or to the cabinet and or the Ministry of Fisheries and Marine Resources and or the Republic of Namibia, the total amount of $150 million Namibian dollars being the approximate market value of 50,000 metric tons of mackerel that was fraudulently allocated to the 11th accused. Whereas in proof and in fact, when the accused person so gave up and pretended as aforesaid, they well knew that there was no fisheries agreement between the governments of Namibia and Angola. And the intended agreement had been downgraded to an MOU on the advice of the Attorney General because Angola did not want to make a separate Namibia. Or the MOU would not be utilized in terms of the relevant provisions of the Marine Resources Act to allocate fish quotas to the 11th accused. E, The MOU itself even had no provision that authorized the fourth accused to allocate fish quotas to the 11th accused to the tune of 50,000 metric tons of the period. Q, the third accused had no mandate to nominate the 11th accused to be given fish quotas. R, the MOU was put in place as a cover-up of the real position of the background. S, the MOU was used to implement the scheme to accuse the device to access fish quotas for exploitation by Samherji group of companies and its aforementioned subsidiaries in Namibia and for the benefit of accused 1 to 6. And 11 to 22, while they were not right quotas in terms of the provisions of the Marine Resources Act 7 2000. D, the MOU was never meant to benefit Namibians suspected in paragraph F above, but it was created solely to benefit accused person. U, accused 11 was not an Angolan company, nor a joint venture with Angolans on real terms, but it was registered as a special purpose vehicle for the accused to access the fish quotas. B, the proceeds from the sale of fish quotas will be distributed amongst the accused for their own personal benefit and of those who claim through them. W, they had positioned themselves to misappropriate the amount of 150 million Namibian dollars in the approximate market value of the 50,000 metric tons of post mackerel that was fraudulently and corruptly allocated to the element accused. X, they had no right to appropriate the 50,000 metric tons of post mackerel and or equivalent monetary value thereof in the penalty. Thus, the accused persons will be treated as
those are two persons who are doing their entities. They are pleading or not pleading, planning, whatever. Can you just be specific that you are also doing for the entities so that you don't keep on asking and mention your entities? Now, this relates this page, this question to 166.
I understand the charges as they are. I just have a question on page 66, just for clarity. And just looking for myself, use one, then I'm going to page 66, the second paragraph starts in that from the date of citing and prosecution before included.
Sorry, can you go slowly? Second paragraph?
Case of page 66. So the sentence starts at in that for the date. And the dates are 18th of June 2014. Then continuing thereafter to 27th of November 2019 and beyond. I don't understand that because I was already arrested on the 27th of November. And then we're speaking of John Show. Accident to discrimination. So they are not continuing on this count while I'm in custody.
Yes, we want to give an explanation.
Yes, the Lordship. The reason and beyond is included. We are dealing with several accused persons in entities in this particular case, and there were some payments which also made after that. So that is why they did. So they were in beyond. I said we are dealing with several entities and accused persons in this case. Allegations are the in common papers. And the reason as to why and beyond is included, there were some payments which were made after that day.
Which date will the give money together or will it give?
Evidence will be made to speak which particular entities may receive funds afterwards.
waiting for your evidence.
I read section 1061F for myself for 17, 18, 19, 20.
Respect of accused 2 and 21. Understand?
Understand the judge?
Yeah, that's right. I understand. It's nonsensical. It doesn't make sense in law and logic. But we read in terms of 106, 1F.
Once more, thank you for giving the opportunity to plead in this very count of indictment, which sounds very malicious and outrageous, in the sense that, okay, well, notwithstanding the fact that I don't have a legal representation, I plead not guilty to this outrageous and malicious allegations.
You understand the judge?
Yes, I do not.
So, did you mention the age?
Do not say anything.
For the age?
There's nothing. There's no anything.
There's no age.
Yes, indeed, Your Worship, that's like the thing of this now.
Yes, Judge. I do. With respect of myself and accused 15 and 16, I plead in terms of section 106, 1F, the CPA, that this court does not have jurisdiction.
It is put at one, we can remind them clearly what
That's it, that's it, Your Worship. It is still 27 to 1. The first alternative to count 8. That the accused are guilty of the crime of contravening section 18, subsection 2A of the Constitutional Assembly Act 17 of 1956. Conspiracy to commit fraud, right with section 84, subsection 2, section 92, 94, 155, and 156, and 33 to 5 of the Trial Procedure Act 51 of 1977 in respect of this 1 to 6. In that, from the date more precisely unknown to the prosecution, but before and including the 8th of December 2011 and continuing thereafter, 27th November 2019, thereafter, and the 8th of year Windhoek in the district of Windhoek and or elsewhere Namibia and or elsewhere outside Namibia, accused 1 to 6 and 11 to prosecute together with a very group of companies and their representatives and acting in one will compete conspire with each other and or one or more of the culpability and describes in count 8. Last accused persons contravened section 18 subsection 2A of the Registration 17 of 1956 as accused section 84 subsection 2, 92, 94, 155, 156 and 332 subsection 5 of the Prosecution Act of 1977.
For the same reason.
Yes, Judge. Would have thought that the plea covers the alternatives, doesn't it?
Sorry?
Doesn't that plea cover the alternatives?
Which people
The plea for the main count.
would not be judged? Because all they are saying is would not be the most serious offense. They include that judge and alternative may include that as alternative. So they will be the evidence that they will try to lead is to prove the main charge and the prevent the second charge, which they may prove may fail.
I don't, it goes from crazy to crazy. I mean, now it's apparently under the Righteous Assembly trying to ascertain people, their mindsets, that they conspired. They haven't disclosed any statement from any. So I don't know. But for the sake of doing what we are doing, for accused 3 and accused 21, in respect of the first alternative and the second alternative, it doesn't change. 161 or 106 1F doesn't change.
So
From crazy to crazy, it doesn't change.
we have read the second alternative as well.
Yeah, as I'm saying, I can grade it from crazy to crazy, yes. It goes further. I mean, it becomes laughable, really seriously.
You know, I'll be assuming we proceed with Shanghala.
Yeah.
I will be very happy to.
No, you see,
No, what I'm simply saying is, yes, that's you are quite right. If an allegation is or a charge is useless, crazy, and so on, you will be quite happy to describe it as such when it's time up.
yeah, no. I didn't want to ask questions because I do understand it. But just to illustrate, on page 67, after age, they then say the accused then did then and there by means of
We are back to where? To which charge now?
paragraph 67, that's the main count. Remember that they, as I'm saying, the now evidence will be led and then it moves now from this competent to the next one. Okay. They said by means of said false pretense, induce their principals and or appointing authority and or the cabinet and or the Ministry of Fisheries and or the government of the Republic of Namibia. Now, no disclosure has been made about whether, because my boss was Chinhengo, his deputy was Nghipunya, they have moved to the Celestial jurisdiction. no statement has been brought, not even by cabinet. And then they move now. From there they say they conspire to commit fraud under the Russian. That's 1 to 6. 1 to 6 is Ricardo, James, myself, Esau, Tamson, and whatever. They've got no statement, you know, and maybe it's going to be extracted, I don't know, sci-fi, I don't know. Then we move from that to theft. Then they say, on dates they don't know, and beyond, that the entire quota allocated to that entity was therefore stolen. I mean, seriously, Judge, it's if you understand, that's why, because I know you don't understand fishermen and your country, but the point is this. This is crazy. And we are spending resources and days here. Or if they just ask and try to understand, these fellows know nothing about fishing. But anyway, to alternative 1 and 2 say, rubbish.
Thank you, Honorable Judge. I like to call Honorable Judge's comrades. This time. Having read the...
If I say I hate that, I'll be lying. I didn't hear that. I didn't hear that.
Let's close that. From the face value, prima facie, this very alternative count really I say this cannot be, in fact, the way we are charged. I've been in fisheries for many years. In the economic ministry's house, from trade, from mines and energy, with the current Secretary General of Zambia during the Marangen time, I was easy. But having said that, my Lord, this very alternative count is not worth the paper. But it will come when it comes to me, to my defense, when I give my evidence. I will, in fact, and notwithstanding Article 2.1 of the Supreme Law of our country. 12, yeah. 12.1. It's for myself. It's only I'm charged in my personal capacity. No.
Secretary